In this video, we're talking about the hearsay objection, and like I like to reduce it sometimes is what would De Niro say? We're really reducing hearsay to just two words. If I am the opponent and the other side is attempting to offend this rule, offend the definition in 801C by introducing an out-of-court statement for the truth of the matter asserted, I need only say two words, voice my objection, and say the basis, hearsay. Objection hearsay. Understand what you've done. You've invoked this very large definition, this very important definition. And essentially what I want to reduce this video to is where the fight is. The fight on hearsay is often, if we're going to talk about definitional, if we're going to talk about the opponent saying you're trying to elicit hearsay and the proponent saying no I'm not, a yes, nuh-uh type debate as it relates to the definitional hearsay, it's often going to come down to the very last part. What is the proponent trying to do? And you have to be introducing not only an out-of-court statement, something a declarant said outside of court, something that we're offering because it's an assertion of something, but it's got to be offered for a particular purpose. It has to be offered to prove those matters that's in quotes, to prove the truth of what that statement says. And I want you to embrace this, that this is the bad purpose. If I am the opponent and I stand up like De Niro at trial and say objection hearsay, I'm saying you, sir, you proponent who are asking questions of this witness or putting in a document, you are attempting to put in an out-of-court statement for the bad purpose, to prove the truth of the matter asserted, to prove the statement that's actually in quotes. If Bob said I got there and the store was already open, that's the quote that the witness is going to relay from Bob. It's out of court. It's a statement by Bob, the out-of-court declarant. He's asserting something. When he got to the store, it was not open. I have to be saying, when I voice objection hearsay, I have to be saying what we're doing, what the proponent's trying to do, is prove exactly what Bob said. And you got to think about this. We're always looking into this relational analysis. What is the proponent trying to do? Connect it up in a relevant sort of way to something that matters, something of consequence at trial. Well, what they're trying to do oftentimes, if you're the one objecting, if you're the one talking about a hearsay statement, you're saying what they're trying to do in this case, why it's relevant, is they're offering it to prove that statement in quotes, for the truth of what's in that statement in quotes, not some other. So that's what the proponent would say. And look at it. The entire article, all the weeks of instruction, everything under Article 8, all those very many rules and lessons that you'll hear are all reduced to one thing from the opponent's perspective. What is the objection? What's the best objection under the circumstances? However the professor or the bar examiners ask the question, objection hearsay. You've done your part as the opponent. The only part left is to react to where the proponent goes. And the responses can really come down into three different categories. First, it's this definition. The response can just be, you're saying objection hearsay, which means you embrace this three-part definition. I'm saying my response is, no, it doesn't. And we'll talk about that a little later. Second one has to do with not hearsay under the rules. We have another rule right after it, right after 801C, which conveys the definition of the rule. We have a definition that says not hearsay, the things that will not qualify, the things for the proponent that automatically are not going to offend the objection hurdle and are going to be allowed in subject to other articles. These have to do with prior consistent statements, out-of-court pretrial identifications, and statements offered against parties, sometimes called party admissions. And lastly, the one that we hear so much about in hearsay, which really is less the issue, at least for me, are all these exceptions, right? Even if it meets this definition, even if it meets an out-of-court statement offered for the truth of the matter asserted, we have our reliability exceptions under 803. Those times when the rule makers tell us these circumstances, if the statement was made under these circumstances, it's reliable enough. Then you have your necessity provisions. If the out-of-court declarant is unavailable, we're saying we really need to put in this statement. It's a necessity under 804, and of course my least favorite rule, the residual exception under 807. But look at all the responses and the pathways to a response that derive from the opponent standing up and saying objection hearsay. We're going to focus on this first column over to the left here, definitional hearsay, and the response to it. So if you look at all these things, again, this top line up here, this is the proponent, right? This is the opponent standing forward and saying objection hearsay. By doing so, right? All you have to do is say those two words, objection, hearsay. De Niro style, you are invoking. You're saying it meets this definition. You're saying it is out of court. That is, it wasn't said here today in this courtroom. You're saying it's a statement. It's some kind of assertion, whether it's conduct or writing or verbal. You're saying it's an assertion by a human, not a machine or an animal. And you're also commenting on the purpose for which the proponent is introducing it. That they, the proponents, the ones asking about this statement, the ones asking about this out-of-court declarant, they are offering this to prove those words and quotes. They are offering this for the bad purpose of hearsay to prove the truth of the matter that's asserted in those quotes. That's what the opponent says, and they do it with two words, objection, hearsay. From there, think about all that the proponent can say. I'm the one asking the questions. I'm the one putting in the exhibit. I'm the one that's sponsoring this hearsay. So I have lots of options as to how to respond. First is you say hearsay and you objection hearsay and you invoke this definition. I say no, not hearsay. Doesn't meet the definition. Maybe it's not a statement. Maybe it's not out of court. Or most popularly in the middle, maybe I'm not offering it for the truth. I'm the proponent. I'm the one who knows why I'm offering evidence at all times. I'm telling you this one's not for the truth. And then again, all the other things that we're not going to talk about here today. But notice that the proponent's the one that can invoke the not hearsay definition in 801D, and the proponent's the one to invoke any exceptions under 803, 804, or 807. But if we focus down on the definitions, it's really the proponent's argument stays here. You say hearsay 1, 2, 3. I say not hearsay because it's not 1 or not 2, or most importantly, 95% of the time where the fight is, not for 3. I am not offering this for the truth of the matter asserted. I'm offering it instead for some other purpose. And you see in the red in the middle of the slide, it says Porter's top 5. Let's talk about those. When you're going to say it's not for truth of the matter asserted, say these. So here we go. Again, that doesn't meet the definition. That's an easy one. Does not a statement. Maybe it's not out of court. 1 and 2 are easy, and less so of the fight. More so, Porter's top 5. The ones that are not offered for truth of the matter asserted. So if my opponent stands up at trial at any time and says objection hearsay, I know one of the things that can be my most immediate tool in my back pocket before I get to all those exceptions and 803 and 804 and residual exceptions of 807. I know I can argue about the definition. And specifically, if I'm going to argue about the definition, if I'm guessing at home, I'm going to argue that it was not offered for the truth of the matter asserted. I am not asking these questions or putting in these exhibits to prove the truth of what's in the quotes, to prove the truth of the matter asserted. Instead, I'm offering it for some other purpose. And the rule's not explicit. I can offer it for any other purpose, as long as it's not to prove the truth of the matter for any other purpose. Here's my top 5. First, you hear this all the time in court, effect on the hearer or effect on the listener. That is, I don't care about the truth of this statement as the proponent and why I introduced it here at trial. I'm just offering it to show what the person who heard the statement did next. I'm giving context for the effect it had on the hearer. Why did the police officer who heard over the scanner that there was something going on at first admission? Well, why did they go to first admission? Because they heard this statement. Doesn't matter if the statement's true. The second one has to do with circumstantial state of mind, not to be confused with 803.3, which is actually commenting on one's state of mind. This is circumstantial evidence of state of mind. This is where when someone says something like, I believe I am in fact Batman, I don't care about the truth of that statement. What I care about is the circumstantial comment it makes on what's going on inside that person's head. Maybe, in fact, that they are not all with it, that they are a little off, that they are crazy because they've said I am in fact Batman. Number 3, impeachment. This is a tough one. Anytime there's someone has said different things on equally reliable occasions, different things at deposition or in a plea statement than here at trial, we say it's offered for impeachment. And what we're really saying is we don't care about the truth of this statement, this prior statement. All we care about is that it's different from today's testimony. We are introducing it because he said different things on different days, not because one or the other is true. So I think you stay away from the question, for instance, of was it the truth today or was it the truth then before at deposition or in a statement? Stay away from that. Your your argument is this is not hearsay. This is not offered for the truth of the matter asserted. Instead, I'm offering this merely for impeachment, merely to show this person said different things on different days. There's legal act and verbal act, which is tough to go into other than the fact that it has independent legal significance. I'm offering this to prove that there was an offer or that there was acceptance or that there was a marriage proposal, not whether this statement that was actually in the quotes is true or not, just that the statement itself has some legal significance, a threat, for instance. And the last one has to do with knowledge or notice. Again, this is not hearsay. It's not offered for the truth of the matter asserted. Instead, I'm offering this just to show that someone was put on notice. Excuse me, Mr. Shop Owner, did you realize that there's ice out in front of your store? Did you realize that it's wet out in front of your store? I don't care if that's a true statement or not. I'm not offering it for its truth. I'm offering it just to show that the hearer, just to show that someone was put on knowledge or notice. So those are the top 5. Those are things you can say if you're guessing. But notice that all the arguments that can come from the objection hearsay from the opponent, and the proponent responds with, no, this doesn't meet that definition. This doesn't meet your 1, 2, 3. Specifically, most times the fight is this is not hearsay, not offered for the truth of the matter asserted. It's for some other purpose, like Porter's top 5.